Numbers that I think are presented to suggest that there is a pretty extraordinary need in the region as people re-enter society and to, and as a means of informing our debate and conversation. And I can make that clear to folks.
Thank you. Appreciate very much your and Rafi's work on this, and want to see if folks have any questions about what you just heard. I got questions. I'm just going to try to let somebody else start out. All right, let me go. I cannot recall, but I'm trying to remember the number that Dr. Austin predicted we would have Orleans Parish individuals coming back from state censuses. Like, you know, at a time in the book, the number was 125 and 250 to 250. So you got this question about sharing costs with other parishes, which as a CIO I'd love to see. But if all these folks are Orleans Parish residents when they left, and most of them presumably are going to come back, it strikes me that that's the right focus, right? Although this is clearly a region, and people are going to end up in St. Bernard and Plaquemine and St. Tammany and St. Charles and Jefferson, all of it as well, right? But the question is, what number, assuming that this reentry function is something that we want to support in New Orleans, what's the right number? And I thought it was 250, not 225, based on Austin's data. Does that make sense?
Yeah, so there are a couple of things there. One is, and correct me, Mr. Sheriff, if I'm wrong, as the state's commitment goes, right now they're willing to fund up to 225 slots. Is that right? So that's what the Secretary explained to us. That's what the Sheriff explained to us. There are some pretty exceptional space limitations that limit the size of the cohort. So
that's our space limitations in New Orleans.
Yeah, that's it.
But if we're dreaming about the future, it
becomes the number that people decide is best. And I'm not sure I have the exact answer, but if you look at Dr. Austin's 250 number, whether you look at these numbers that the Secretary sent, and albeit these are, there are a lot of nuances here, but just on base level releases in 2010, coming from DOC, the total number was 3551 for the region. The majority of those 1,637 Jackson, 1,532 from Orleans. You can see the majority of those folks are coming back to this region. The question is, how many of them are getting services in the state prison they're in? Something that the Secretary brought up that's been discussed around the table. How many of those folks are in DOC care but are in local jails in other parts of the state and not therefore getting services, who then are being dropped back into New Orleans, a society without the advantage of these reentry services, right? Because that's something to consider. And obviously, how do we want to, as much as possible, reduce recidivism of those DOC inmates by having local availability? And I think there's a tension there because some folks also feel very adamantly that why should Orleans Parish be responsible for the region? And what does that look like? Is that a way to grow the size of the jail, and how are we going to manage that? I think those things we don't exactly have answers for them yet, but those are things that have to be considered.
How long does the reentry program usually last? I mean, how many of the 15, assuming we went to 225, would we handle 225 of the 1,500 that are coming back to Orleans in a year, or would we handle 1,000 of them?
I'm pretty sure how long is it cycle on a 90-day? I should know this. 90-day cycle. So it's not 225 a year. If you're fully ramped up at level, you could potentially have up to 900 folks going through a year at 225 or 1,000 to 250.
So we could potentially take 2/3 of that 1,500 at a 225 size on a 90-day cycle.
Yeah. And it gets more complicated because when we say reentry, in some cases that means skill training, we're talking educational services, in some cases we're talking work release for people who already have skills, who are ready to go do some things. You have community service. And there are a bunch of, so people enter in different places. Everybody doesn't enter in the same place.
But just for me, if there's somebody from New Orleans in DeSoto Parish Jail,
Yeah,
and we can bring them back to a high-quality release program in Orleans Parish before they're back home, that'd be a good thing.
yeah.
That's my
And while it's not fully
personal-
ramped up for spatial and timeline reasons, the aspiration is to have family visits, to have families involved in programming. The sheriff has been meeting with local businesses. And again, I think there's some serious questions about whether folks believe those services should be in the jail, quite candidly, or whether they should be outside of the jail. And that's a conversation that has to inform this, but it's a bit different than the one that you're asking about.
And then the other question was about money. You based the 225 not on the population, but based on what the Department of Corrections said they would fund. And so I got two questions. Is that the right number? It may not be enough.
No.
And then is the number per person enough for the kind of quality program that we'd like to see? Because I remember when we heard about the quality programs that other people are doing, they were a lot more expensive. And obviously we can't afford the Cadillac on the Kia budget, but we want to make sure we get a Kia as opposed to, you know, I don't know what.
Well,
All right, a gremlin, you know, that we got out of the junkyard,
Yeah.
right? We want a quality program, and that's one that's affordable for us, but also,
The reason why we mentioned the mapping of assets and resources connected to the financials is because whether you pick the institutional model or whether you pick the community services model, there is still a significant cost attached to that. I don't think we know what that is. At least no one I know have seen those numbers. And because we haven't mapped those assets and mapped the need in a way that's coherent, we don't have an answer for that. And that is, quite frankly, a fairly significant undertaking to get a handle on what that would look like. The other side of that, Amy, just to finish answering your question, is value. 225, 250 is not enough for the number of people that are being released back into the region. If it's what we get, we'll take it. But I think there are a lot of folks who believe that people should have a lot more people should have access to reentry services, however you define that, as a means of improving their quality of life, reducing crime, increasing justice, and rehabilitation.
other questions. Councilmember Pivoy.
Hope these aren't too basic, but if the program is run by a community group and not by the sheriff, then the inmates still reside in the prison?
Yeah, what we were suggesting by way of that second option was a more elaborate option that would include maybe MOUs or agreements between Orleans Parish Prison, the state, and community service agencies that could provide some of those services by way of contract or MOUs or what have you.
And then where would the services be given, performed?
It depends on which ones we're talking about.
Okay,
It would
but
be-
they would still go back to the jail at night?
For those that are still in state custody, yes.
Okay, right. And then your last sentence, this has to be weighed against the decisive opinion of the CJWG that allowance of state prisoners in local jail constitutes poor policy. Could you tell us why they said it was poor policy?
I'm talking about this working group, and so maybe
Oh,
I'm
us. Oh,
overstating,
okay.
maybe I'm overstating the sentiment.
Okay.
And if so, you guys should probably just tell me so I can, but in our discussion, we thought this would have a fairly robust conversation about a number of things, and when that topic came up, there was a strong sense that, well, in the best case scenario, and as we saw with many of the best practice presentations, that a lot of those services were held outside of the institution very intentionally as a means of extending that person's reentry and easing that person's reentry. Councilwoman, I don't pretend to be an expert, and so I'd love to hear from other people as we go along about the details of that. That was the
Okay, no, I thought there was some other group that had
No, I meant, that was
this
this one.
one. Okay, great, thank you.
Are there other questions before we close out? affectionate comment. I'm going to give my interpretation of what Flozell and you just had a conversation about, which is, I have not assigned members of this group to say, okay, come up with the policy for us to recommend how many state prisoners to house in Orleans Parish, if any, outside of the context of work release and reentry. There's certainly room for that discussion if this group wanted to go that direction. And so I don't want to, by omission, pretend that conversation hasn't been part of the conversation. And so I think that you captured the sentiment of the majority of folks on this group that for reentry and work release, that would be the priority for state prisoners. There are other arguments that can be made for the housing of state prisoners in the local jail, financial, job creation, etc. Quality services, you name it. We haven't assigned a task force, a task group on that topic, and we could. So if somebody wanted to volunteer to do that, that would give us the forum to have that conversation that you all just had. This didn't do that. And I want to be real clear. We didn't do it by omission. I wanted to make sure we put that on the table and address it and say that's one of the options that we can have a recommendation. And right now, there's nobody working on that recommendation outside of the reentry work release conversation. But clearly, again, then to broaden that statement, because we are a region, whether somebody comes back to Jefferson Parish or St. Bernard Parish or Orleans Parish, we're all going to be interested in their successful reentry, right? Because the folks who got in trouble and went to jail the first time don't really care where the parish line is, right? And so, to a certain extent, if we think reentry is a good thing, we would rather have the region, in my opinion, all embrace reentry and successful reentry programming to make sure that whether you're coming back to Orleans or Jefferson or Blackwood's, you've got a good experience. Now, we shouldn't have to pay for all of it in New Orleans, right? We should share that responsibility. That's my point of view. So there's an opportunity for more reentry than just for New Orleans folks. The question is, who should pay for that? And how much is the state willing to pay? And how much are we willing to pay in terms of operating capital and infrastructure to do that? But I think it's fair to say we do have an interest, not alone, but we do have an interest in making sure that that's well done. Folks, prosperous life. Welcome, Judge Gray.
I'm back.
Yes, ma'am.
Sorry I've been away. I have a couple of concerns about that conversation, and I'm sorry I was on a conference call. So, right, regionally we do have an interest in everybody having a good experience, and they have facilities in Jefferson Parish for that, and so as we're trying to figure out what are the right numbers for Orleans Parish, I'm a little concerned about why we're factoring in numbers for other parishes in the region. Regionally, that is a lofty goal. But our responsibility here are for people who are in Orleans. And there is, as I understood it, a concern, mine and a couple of other people, about the size of the facility. And so if we're talking about what is the right size for Orleans, why then are we factoring in numbers for people who are not in Orleans? I just don't get that.
So I'm going to clarify, as soon as Flozell's recommendation, his recommendation was based on 225 folks, which the state has told us they would fund, who would all be Orleans Parish residents, at least were Orleans Parish residents when they were incarcerated the first time. So I was just raising the broader...
reentry?
For reentry. So I was raising the broader question about, you could have a conversation, we could, about whether we share an interest in seeing, on a regional basis, strong and successful reentry programs across the region, because there's gonna be some folks moving across parish lines, to live, to work, and if they're gonna offend again, potentially to offend again. And so I think that was the nature of my comment, but I think your point's well taken, which is clearly our first priority can and must be the city of New Orleans, and most of the folks I think are gonna come back to the city of New Orleans, and they're not gonna be crossing that line. But I think you can make an argument that if somebody was willing to fund us fully, that we might have an interest in making sure we have a regional approach. But if you say there's well-funded
We can have a
programs in
regional-
Jefferson, if there's well-funded programs elsewhere, then it's not necessary. We have an interest in making sure they've got a good program, but not necessarily doing it ourselves.
Right, and we can have a regional approach that doesn't require us taking on the responsibility though for all of the individuals, and that approach though would require that regionally we sit down with representatives from the other parishes and get a commitment from them about what they are willing to do, but not having a conversation in Orleans about the region. We can't do that just by ourselves. We have to have the other people in the room. And I'm sorry I've been absent, but so I have this question about reentry. The models that I'm familiar with, and they're not all juvenile, although I do juvenile work, don't usually require that the persons come back to a prison. It is supposed to be a step down into getting them back into the normal community. And so the model for beds for reentry is sort of interesting and not what I think we ought to be doing.
So, Judge, if I could, you posed an interesting question that came up in our conversation about the difference between reentry and pre-release programs. Right? And so we didn't answer that question, and it's something that I think this group has to make a decision on, in addition to the former question about the will of this group concerning whether we're going to entertain the regional conversation or whether we're going to have a local conversation. Because it's very difficult to do, well, you can do the analysis on both, but we'd rather not, quite frankly. We'd rather have a conversation about what we think is the best opportunity and then design reentry programming around that decision. But we were acknowledging that there is a current contract and a current program in place, and trying to figure out practically, if that's where the funding is coming from, how do we make a suggestion or acknowledge that that option is there and how it can be improved, while simultaneously saying that there is a vision or a developing vision for what reentry programming can look like. But we have to make, I think, a decision about whether we're having a local discussion or regional, and all the challenges that go with having a regional. And we don't have guidance from this group about which direction.
And let me be clear, I probably put us off on the wild goose chase. The recommendation from Flozell was specifically about Orleans Parish and a size to accommodate Orleans Parish. I was just speculating about a broader conversation that could be held among our regional partners, Judge. Michael?
Mr. Chairman, I just want to clarify one point. My understanding is that the current reentry initiative isn't just an agreement about Orleans Parish, but it is multiple parishes. And so I thought that 225 number was not exclusive to Orleans Parish prisoners.
I think that's the case. Now, practically speaking, maybe the sheriff can tell us, because I'm not absolutely certain, but because of the size limitations, I think the majority, if not all of the current participants are Orleans Parish, because they're limited by space to about 60 members per cohort. But as I understand it, the contract calls for a regional
But if we were to grow
yeah.
to what the state is asking us to do, which is 225, could we not tell the state we want them to be Orleans Parish
No,
folks?
we don't want 225 reentry beds in Orleans Parish.
Well,
So that's a different
so
question.
Right.
You're very much entitled to your opinion on that
Yeah,
issue,
right.
and the group will get to vote on that. But
No.
the question is that whatever the number is, can't we tell the state, sorry?
Well, you can tell the state whatever we choose to, but their current design in the 3 sites is regional. It's not, just 1 and 3/4 is only for that parish, or, Boulder, that. It's regional. And the other one, wherever it is, I can't remember. all three sites are designed as regional centers that have a certain catchment area. And so we sort of, folks can have a conversation, but right now the design is what it is.
We have a dissenting opinion from Judge Graham on your recommendation. Any other questions or comments?
I like this.
All right, hearing that, let's move on to the second report on racial disparities. And we have the trio of Superintendent Surpass, Pastor Barrier, and Mr. Diaz. Why don't you get the mic from
This is working. Given the limitation of time, the chief and Pastor Barry and I had a conversation about what we could put together that would launch the conversation forward, because we can't address racial disparities here now. And nor do we have time between the last meeting to today to address such a question. Since we're looking at historical perspectives, we're looking at the question of institutionalized sort of prejudices and other issues that affect men of color, but specifically young black men. We felt that there was enough information already that pointed to that possibility, and so we highlighted that in the background information. We recorded Dr. Austin's statement, which I'll read out loud real quickly, where it says, males and blacks have significantly longer lengths of stay. Specifically, males have an overall length of stay of 22 days versus 10 days for females. For blacks, they have a length of stay of 23 days versus 11 days for whites and 5 days for Hispanics. These length of stays differentials result in these categories of inmates, quote, stacking up in the OPP population. He further added that when one controls for the type of charge one is booked for, blacks continue to show a longer length of stay, although the overall difference is reduced. And that further suggests that a more detailed study, according to Dr. Austin, should be conducted to determine the basis for the longer length of stay for blacks. Additionally, in the Department of Justice report that was recently released, they find some civil rights infractions around the issue of racial profiling with black men in this community. And from page 34, they state, reasonable cause to believe that there is a pattern or practice of unconstitutional conduct and or violations of federal law with respect to discriminatory policing exists, right? So clearly we have experts already that have been on the ground looking at the data, articulating that such a problem exists. And we felt that moving forward, there has to be something set up to start to really do some deep sort of analysis of the situation. Look at the history, look at the patterns and practices, look at how policy affects it. And so we thought about several options that we highlighted 1 through 5 under the options section. 1, obviously, to pursue Dr. Austin's recommendation to conduct a detailed study of the longer length of stay of black men in Orleans Parish Prison. 2, establish some formal mechanism that involves the community in this process as we investigate, research, recommend, or monitor policies and other practices that contribute to the creation of racial disparities. Authorizing some form of quality check on an annual basis that evaluates how we're doing on some kind of racial disparity meter that we can set up, whatever that may be. Establish ongoing annual goals and outcomes for the entire system to benchmark ourselves annually on what is acceptable, what is not acceptable. We have to define it, we have to understand it. And 5, since the city of New Orleans and the city council, the mayor's office and the city council all have some significant input in criminal justice funding, to tie that to racial disparities, to tie your outcomes-based measurement sort of model to the racial disparities issue in criminal justice funding. So those are several options, and in the recommendations, obviously you can take all those options and look at all of them, which we recommended in recommendation number 1. And then in addition to recommendation number 1, take my newly created position, which I now occupy, the Office of Neighborhood Engagement, to create the community mechanism for involvement in this process. And 3, to provide some sort of unified city government leadership statement out of either city council or the mayor or combined that acknowledges these findings and sets the tone for continued work.
Thank you. And Lucas, since you did allude to it, want to congratulate you again and introduce you to the audience as the mayor's new director of the Office of Neighborhood Engagement. And we didn't want to release you from service on this task force at this point, given your hard work. But at some point we may get to do that so that Puentes again would have leadership directly on this task force, but you wear two hats pretty well. So thank you very much for joining the administration and for your report. Are there questions for Mr. Diaz, Pastor Barrier, Chief Surpass about the recommendations? Close up.
Gentlemen, I know we're getting different reports. One of the things that we thought about as we did our work was how all of these things are really interconnected. And it would be great when we can start connecting the dots in them. So I know we'll hear directly today about bond schedules and the like. But I'm curious, in your assessment so far, what are you seeing by way of economic injustices, by way of racial disparity? People of color tend to be less able to pay bail and to hire talent to represent themselves and to be able to participate in democracy because of economic issues. Has that surfaced yet, or have you seen any of that so far?
Again, we haven't had the time to do that kind of analysis. That's why we're recommending that it be done, and to actually have experts look at that and analyze it and weigh it with some good comparative models that are both local and national to figure out what's really happening there. But I can't answer that right now.
Other question? Comments, Mike?
Just an observation. I think really this is not a proposal for a committee. It's, in my view, it's a proposal for a working group of its own on an issue of this kind of substance. And I would fully support that.
So you actually recommend that they add to their recommendations, which is not just doing what they suggested, but really have an ongoing group designed to
This is
review the
more work.
findings and address them in substantive ways.
This is more work than a three-person committee.
Well, right. And they can make some recommendations and then would, I think, hand it off. Your proposal is hand it off to whom? Why not hand it off to a working group on addressing racial disparities? And that's something that you guys should review and come back with a recommendation as to whether you think that's a good idea, and if so, what does that look like? That's great. I've got a question about number 5. Everybody knows I love trying to figure out how to tie resources to particular behaviors. I'm trying to figure out how I would do that if that was my job as the chief budget officer for the city, which is if the judges are giving racially disparate sentences, do I not fund them? So, I mean, I'm trying to figure out how that looks, or how that works, or if the police continue a practice if that's documented. If we document a police practice that leads to this, should I train the officers to not do that and hold accountable the folks who do that, or should I not fund them?
So that's the question we have to figure out. How does that happen? Because how are you going to hold the various players in the system accountable to do the right thing? If we look at the historical systemic behavior, nothing has happened with it, which is why we have experts finding what they're finding today, which is why we have the Department of Justice Civil Rights Division finding what they're finding today. So do we have the answer for that? No. But can there be some mechanism to hold these agencies accountable and compare their results and their performance according to some sort of metrical measurement about the number of black men in the jail system, and is that proportional or disproportionate? I don't know the answer, but I would imagine something can be established. And what the remedies are, that will depend on city council vote and decisions by other folks at this table.
Fair enough. I mean, I'm all about doing the counting, because if you don't know what you're counting, you can't take action to change it and measure your progress towards your goal. I'm just not sure whether the accountability measure is to fire somebody versus to not give them money, but that's something to work on.
That's substantively different.
Yes, sir. It may feel the same, but anyway, and there's clearly a lot of different actors, and then there are folks that the mayor can fire, and folks that the voters have to fire, who play different roles. Including, I guess the voters can fire any of the elected officials up into including the mayor. So we've got all those folks with various different types of accountability. Other questions or comments on this particular report? Joe?
Well, just following what you're saying about how do you measure, I think first of all, I think it's difficult, but there are models for how folks are held accountable for disproportionate minority confinement, contact, however you want to term it, and usually the studies are interdepartmental, interagency, because there are decision points that are made at every point of contact that lead to or can exacerbate or lead to disproportionate minority contact in the criminal justice system. And what the Justice Department usually requires or has required for a long time was each state through their correctional systems had to have a plan. Without a plan, they would get a reduction in their eligibility for grants. Now, how they work that plan becomes difficult to implement. How effective they were is always something that requires a whole lot of moving parts, but having a plan on the books was one step that the federal government thought was a good idea for the states. And we can require that for some of our agencies who come into contact with the community may unconsciously or consciously, depending on who's doing the work, be exacerbating this particular problem and have a plan for what maybe.
That's great. So there's a solution to my problem. I couldn't figure that out, but somebody's already done it. So, thank you. Other comments or questions on this particular report? Hearing none, let's move on to bond schedules. And Derwin Button will speak about your work with Judge Landry Johnson.
All right, well, Judge Landry Johnson apologizes for not being able to be here. She told me this was likely. She, I think, just started either an attempt murder or a second degree yesterday, and so it's not done. So she apologizes, and after much consultation, finally trusted me to do this on my own and on her behalf. And so, just to be brief, our job was bail schedules, bond schedules, however you want to term it. We use them interchangeably in our report. And what was the sort of propriety of having a bond schedule here in Orleans Parish? We know they do this in other parishes. We know they do it in other states. And so there's not a lot of scholarly material on it, but there were a lot of examples. And the way we looked at it was we begin with the purpose of bail, so folks can look at that. And bail is really meant to be basically an anchor for you to the criminal justice system so that you keep coming back for your court appearances. And we looked at it within the context of pretrial services. Bond schedules put you basically on a matrix, essentially, usually based on crime, and it's usually used in that period from arrest until you see a judicial officer. That's usually when a schedule, that's generally when it's used. Sometimes it's used afterwards, sometimes it's used throughout. But generally speaking, the most use out of a bond schedule is when you are picked up and you want to know can you pay to get out, or how much can you pay to get out. And that's generally how bond schedules work. And the way we looked at it was within the context of pretrial services, as because we are very much aware of about $500,000 that the DOJ has sunk into Orleans for pretrial services. How do they coexist? And based on what we looked at, the bond schedule would be something on the back end. Not everybody who comes through is going to be screening releasable. Not everybody who comes through, given current resources and programmatic resources available, is going to be able to be released with supervision that is going to satisfy stakeholders or a judicial officer. And so on the back end, those folks who don't screen through, it is their right, and it is within the discretion of the court to set a bond. And we thought it a good idea to have a bond schedule to guide, not handcuff the judiciary in making bond decisions based on input from the stakeholders and the person standing before them asking for the bond. And so that was essentially, those are essentially our recommendations, is that we do engage to create a bond schedule, and we use it on the back end of pretrial services, and that the process in creating that schedule is an inclusive one, and in that it be used as a guide for judicial officers setting the bonds, taking into account the whole person as contemplated by the law governing bail. So, short and sweet, we think there should be one, but we have to be mindful of appropriate safeguards and using it in harmony with a pretrial services regime.
So, walk me through what that means to be on the back end of a robust pretrial services regime.
Well, what it means is, the way we would sort of envision it is, the person gets arrested, and there should be a risk assessment instrument that that person is run through with pretrial services. That risk assessment instrument is going to dictate a certain recommendation. Sometimes it's going to be send them home on their own cognizance. Sometimes it's going to be electronic monitoring. In juvenile court, it's with a mentor or advocate. So there's a whole range of supervisory conditions, drug testing, any of which can be placed upon that person, and they would be basically released with those conditions. For some folks, we may not have the resources to provide the supervisory structures for them. So one thing that can be an anchor for them is setting a bond. They've got some money on the table, basically. That is essentially a condition for their release. And so that's what we mean by the back end, is that because pretrial services generally are individualized determinations based on your risk, and then there's programmatic resources that are brought to bear to keep your risk low and keep you coming back to court. One of those things, albeit rudimentary in terms of what can keep you coming back to court, is you might lose some money if you don't. So that's what we mean. But it's also, or a lot of money. Well, and that's where the judiciary comes in. They'll be taking into account how much money is a lot of money. If you've got $5 on the table, as Andy Copeland, you might be willing to part with $5 and not come to court anymore. But if it's, for someone in your position or mine, a little bit more money, like $10, I'd come back to court. I can't lose $10. But some other folks might need a little more skin in the game. So, and again, we thought it's a sort of inherent tension. The other thing about money bond is it's inherently discriminatory. So you can mitigate it by having all the stakeholders trying to come up with a schedule that provides a little uniformity and some predictability. But again, we had to confront the fact that it is inherently discriminatory. If you got money, you make bond. You don't have money, you don't make bond. And using it too heavily, you run the risk of sending the affluent, dangerous person home while keeping the poor, not so dangerous person in jail. So those are the risks you get with a money bond regime. And on balance, we thought, at least until our pretrial services can ramp up, put it on the back end.
Any other questions? Or comments? Judge Allen?
I'm assuming all these stakeholders and the economists that we're going to get with and all these other are going to, when the person gets out and kills somebody, is going to stand next to the judge and say, we did this evaluation. What do you think the press is going to just say, no problems? Hey, I mean, I can see me, I'd have to bury Mr. Cannizzaro if I said, well, Leon, I took the work with an economist to develop a methodology for establishing this bond, and I hope you can explain it to the public. I think the law is fine. 334, it says, in determining the type and the amount of bail to assure the presence of the arrestee, the court is to consider. It's not the court at all, it's the court. And if folks don't like it, then they have the law repealed. And, you know, I've never had a non-civil conversation with Leon Cannizzaro in my life, but he would be right to be in my office the next day as you would be if we have it. But in the end, you know, I haven't talked to Judge Sens, he can speak to it, or Judge Gray, but it's marginalizing the judiciary. I have no problem with misdemeanors with a bail schedule or something like this. But any felony, a judge is responsible in the end. I've yet to see someone get out and commit a serious crime and the city council or the mayor or the chief administrative officer say, well, judge did the best he could with what he had. And that's why he makes a recommendation on grand jury indictments and we follow. But realistically, I want to be a willing participant and consider everything. But misdemeanors, I'm fine with. Any felony, I am not going to relinquish the, you know, my obligation as a constitutional officer.
Derwin, I guess what Judge Alicorn has said, I'm about to echo in that I question a bail schedule for state court judges for felony offenses. To my knowledge, again, I could be wrong on this, but I would think that if we're going to do something at this level, this would have to require sort of a state schedule for the entire state of Louisiana, something that the legislature may have to approve. If you're simply talking about putting some sort of a bail schedule together, and you did preface it by saying this was a recommendation, this was not meant to be binding, but I think Judge Alicorn is correct that regardless of what I might recommend as to what a bond may be, regardless of what you might recommend, we could recommend the exact same dollar amount, but if the judge in his discretion believes, based upon factors that are available to him, we're both out of bounds, then he has the right to do that. So again, I sort of question, I think in a different way, as Judge Alicorn has, about the utility of this, the value of this, because I'm not quite sure that at the end of the day, the judge is bound by this. And I think, you know, to some extent, it's in their discretion to make that decision. I think you and I go into court and make the recommendations to the judge based upon our research with regard to the individual who is presented. So I do question this because it may well be in conflict with several of the state provisions also under in the bail articles.
And we took a look at that, and Article 334 does allow for the adoption of a bail schedule. And I'm actually not going to disagree with either of you, and I think we put it in, you know, there's a long version of this. There is a right to bail, and it is the province of the judiciary to do it. Part of the recommendation of the bond schedule is getting folks to operate collaboratively and trying to mitigate some of the disparities, for example, and trying to get some uniformity, some ease, predictability. but also understanding that bail as a security is not a public safety tool necessarily. That is, there's not a big connection between money bond and safety. There is a big connection in getting folks to show up a lot of times. And the way the law sets it out is that bail is supposed to ensure people's presence. So I'm not disagreeing with you, I'm not disagreeing with the judge, and that's part of this process. It is entirely the province of the court. The recommendation, I think, more articulates that trying to get to the point of predictability, uniformity, mitigate some disparities, we all work together on a guide so that the judiciary can make a decision based on what stakeholders have sort of come together and thought was reasonable, for example. And, you know, I'm not Pollyanna-ish, so I'm not going to say if somebody gets out and does something wrong, everybody's going to say, kumbaya, we all came up with this schedule. Judge Alarcon was well within it. We're not going to blame him. You know, I wish that were true, and I wish that were true for all of us. We all get blamed at certain levels for different things. But it is my belief that with that sort of input, we can mitigate some of what goes down, and we can use our experience. It's not like we don't have any experience in this to come up with these schedules for some of this stuff. So all that is to say, I think there's work that can be done. I think it's something available to us, and I think it would be helpful.
Other questions or comments? I've got a question because I fundamentally don't understand something. And I guess the question is does the bail schedule, the bond schedule, envision a risk assessment having been done? And that would help folks place a particular individual along the continuum of that schedule and say, aha, the risk assessment says this, the schedule says this, so if I put the two together, the bond ought to be $25,000. Is that how you get to that point?
The short answer is from us, yes, but that would also be something that would be for the pleasure of the group and for the acceptance of the judiciary. We want everything. That's why we said on the back end, because you have the benefit of the risk assessment instrument, you would have the benefit of at least contemplating other supervisory tools to get the individual back to the court on time, and along with your own experience as a jurist, and the arguments from defense and prosecutors.
But so, just so I make sure I understand the recommendation, the bond schedule is non-binding. Each judge would, under your proposal, set bond at whatever he or she wants to set bond at, as is his or her authority under the law.
Right.
So it doesn't matter what the schedule says because it's a guide.
Right.
But the guide is informed by a risk assessment. There's a risk assessment that gets matched. So I guess, okay, I understand that. I guess my question to Judge Alarcon is, if you guys, you all don't have a risk assessment other than, I mean, there's not a formal risk assessment that's being used other than your experience, right?
334.
That's what we present to them, Andy. That's
Okay.
what we do at the magistrate court. We present to the judges what we think the risks are. There are certain factors that are spelled out in the code. For instance, a risk assessment is, for instance, a gun. If a gun is involved in a case, that says certain things to the judge that it takes away some of his discretion. If the person has been out on a bond before and hasn't shown up for court, that's another factor that enters into the judge's determination. If it's a crime of violence, the judge takes that into account. So again, not to say that this is somewhat an exercise in futility, but
I'm leaning in that direction because, again, regardless of what we agree, Derwin and I can go into the courtroom and say, Judge, we think this guy should be let out on a $5,000 bond. The judge says, no way, I'm not going to do it. He can go up or down in what he thinks is appropriate. Now, sure, we can ask an appellate court to look at that for an abuse of his discretion, but I can assure you that's a very long shot from either of our perspectives. So,
Well, again, I would say it may be an exercise in futility, but it sounds like you just laid out a guide.
but again,
I
I'm
mean,
saying
is
the guide
isn't that sort of a guide that
but
you
the
got?
guide is in our code of criminal procedure and it's been there. The guide is in the code of criminal procedure and it's there right now and it's been there for the last 50 years.
Well,
Okay, so
what a
where's
risk-
the use of a gun?
I'm sorry.
Is the use of a gun in 334 somewhere?
No, it's not, but there are in some other provisions. He doesn't have all the 330s. It's in the 330 series. But if you look at the last, it says any other factor, so it gives a catch-all for the judge to also take into account any other factor or circumstance that he thinks is important.
And I think what has been done with, because we actually have an example of this, a risk assessment tool working in juvenile court. And what it does do is take into account these factors. And folks have come together and created an instrument based on these factors and others to determine how they get weighted, for example. And so there's a score that is basically spat out to figure out whether or not, and there is room for override and things like that. But what it does is it does provide for some predictability. I don't think it's an exercise in futility because while these factors do exist and are supposed to be weighed by the judiciary, and I do believe they do, and there's nothing about a risk assessment instrument that would stop that from happening. What we do get is a tool that can more objectively measure those different risks and by doing so manage our detention or jail populations. And Judge Gray is here and might be able to speak to what goes on in juvenile court with their risk assessment instrument and their sort of success or non-successful folks showing up for court or rearrests. But while I was in juvenile court, it actually worked. It helped manage the population in Youth Study Center quite well. We had folks in anywhere from the mid-90s to high 90% who would show back up for their subsequent dates. We had very low percentages of folks reoffending while out based on their risk assessment score. So, and you could measure it. It was something you could actually measure. It wasn't a feel about it. It wasn't the sort of. It was more quantitative information than the qualitative sort of world we live in right now in criminal court. So I don't think it's an exercise in futility. I think a bond schedule can work. Probably more importantly is getting pretrial services and a good risk assessment put together, but I don't believe it's an exercise in futility.
Yeah, Judge Allen.
Two points to how it works realistically is that a lot of times we'll get a case, the police will arrest someone for criminal trespass, and the person has a background of 2 previous convictions for burglary. Well, a lot of times, especially after the storm, and even until recently, they'll be picked up in the backyard or something. They're charged legitimately with criminal trespass, but I've got to look at it. There's a bond schedule in place. Is this really a criminal trespass based on the record? On the other hand, the district attorney charges a number of people with possession with intent to distribute. Sometimes the police arrested them for simple possession. I find probable cause for simple possession. As a matter of course, I'll reduce the bond. The state has a right to object. So the process goes into effect. And there's nothing more frustrating than I get a lot from the police department is that a lot of times the charge, they're out before they even have a chance to make the case back on the street. That's what bothers me a little bit with bond schedule. And on the other hand, the district attorney can charge people no matter what they're arrested for. And I think people miss that point, that a lot of times the police officer's done a very good job, and I have found no probable cause to, especially possession with intent to distribute drugs. I think it's more for personal use or simple possession, the state objects and the bond say $100,000, I'll release it, I'll reduce it to what I think simple possession could be. But on the other hand, and I don't know, maybe the chief wants to address it, a lot of times people are arrested for things that may not be indicative of what the crime is. It's based on a policeman's best knowledge, and I guess the best example as I have is folks who are involved in burglaries are picked up for criminal trespass because they're only in the backyard. They haven't had a chance to get into the house because of a proactive police department. And obviously I've got to look at it to see what's going on with it. So.
Anybody else want to comment on this one? All right. Hearing none, I'm not sure that you have all the votes you need yet, Derwin, but we will continue to discuss these things. And again, that's the reason we're bringing them up, is to air out the issues and see if there are things that can be done to address some of the concerns that gets raised. And we'll move on to, again, I'm skipping mine until the next time in order to complete all the conversations I need to about funding. And so we now move to actually what Derwin said was the most important part of this, which was actually the pretrial release and diversion program. And I've got, Jerry, you guys want to defer, or you want to move on, or?
We don't quite have our presentation ready yet. And I think we probably need another conversation or two to do that.
Since I'm in the same boat as the two of you all, I'm completely sympathetic. Are there any other comments from the group up here? Then let me spend a few minutes for public comment. And does anybody have any public comment for us today? I've got, yes, gentleman with a hat on the far right.
Go for it.
Yes, sir.
Go ahead.
Yes, sir. My comment is centered around the bond issue, having that previous experience in this area. The right to have a bond is part of the United States Constitution. 334 is part of the Louisiana Constitution. What may not be common knowledge is that the only reason for a bond is that John Doe will come back to court. And for this, you have a bonding industry that gets people out of jail on bond. It is the responsibility of the bail bond industry to get John Doe back to court, either voluntarily, on his own, because they have covered him at 10%, or if he decides not to come back to court, to call what's called his indemnitor, which is usually his mother, father, or grandmother, that will tell you exactly where John Doe is. Because if they don't, they will lose the whole 100% of the bond of their property. This works. It works better than anything else, because if they can't do that, you all would charge the bonding company 100% of that bond. There's no system that works, because if you were self-insured as a bail bond agency yourself, you wouldn't charge yourself anything. So there'd be no motivation to go get John Doe if he doesn't show up. Bail bondsmen are motivated, and they have wide latitude across state lines and country lines to get their property back, because a bonded person is their property. They can go get him and bring him back. The second thing is, as it relates to people having bond, is the cost factor. What does it cost somebody, not just what the bond is, what does it cost them to get out of jail on that particular bond? In New Orleans, in Jefferson Parish, the bond percentage is 13%. That's 3% or 30% more than what it should cost, because the bonding company only charges 10%. So you got 3% going to the court, to the clerk's office, and to the sheriff's office for absolutely, positively nothing at all, except the right to collect money. That affects what a person has to pay to get John Doe out of jail. If it's a $10,000 bond, instead of paying $1,000, they are obligated to pay $1,300. And that 3% is collected before anybody gets any money from the bonding company. That has a major impact on why your jails are full, because they can't afford to get them out of jail. If you're gonna improve your pretrial services, that by itself should have a great impact on whether or not people come back to court. Because if they got a lawyer, they come into court. Why would you hire a lawyer if you're not coming to court? If they're in a rehab program where they honestly and sincerely trying to turn lives around, they will come back to court, because that progress is presented on their behalf in court. So the essence of what you're saying is, are you really serious about giving the money that you spend in other places and putting it in rehab programs or pretrial services? Because if that work, they're coming back to court. The last point I want to make is that bonds are set not because of the nature of the charge, because your pretrial schedule will take care of that. If learned men with honorable intent set a bond based upon the charge, it will be across the board, parish to parish, it will affect everybody the same way. You got fair market value for that charge. But if you got people posting bonds because they're afraid of the exposure they're going to get, if John Doe gets out of jail and commits a second crime, that is not a fair consideration for posting a bond. That's covering their behinds by making sure they have zero risk for failure of what John Doe might do. That is not part of the Constitution. You are violating his rights. All you got to do is have a system where he comes back to court. You can't control his behavior by locking him up if he's going to come back to court. That's my contribution to the conversation.
Thank you, Norris.
To follow up on Donald, I think this bond conversation started off with Lucas' conversation about the racial disparities, why we have so many young black men in jail as opposed to their counterparts when all things are considered equal, that the bond should have been equal. The black man shouldn't have got a $50,000 bond and the white kid got an ROR. But that's another day, another time. Mine is to Mr. Daniels' presentation about this letter from the secretary. And I think if we look closely to paragraph 2, I wish everybody turn to paragraph 2. Because this is the key to this whole thing about what the secretary's intent. Maybe it's totally separate apart from what the sheriff idea is. This is strictly in reference to folks who are sitting in local jail. That responsibility for the rehabilitation falls on the state. 15.828, the large statute of rehabilitation. So the department is shirking their responsibility by taking our local folks, sending them to northern Louisiana. If they have their best interest in heart, don't transfer them out to local jail. Leave them in the local jail, they already got a base where they can start. Because if they've been sitting up in Pine Prairie somewhere for 6 years, coming to Orleans Parish for 90 days, ain't gonna do nothing for them. Because they've been sitting in Pine Prairie playing dominoes and spades. Because they don't have no access to no rehabilitation program inside those local jails. And so we're going to be serious about creating opportunities for guys to come back out, acclimate themselves back to the environment. We got to look at the letter of what he said. This is for folks coming out of local jails. You know why? Because everybody's in a correctional environment, they're coming out with evolving skills. They're coming out with some type of academic improvement. That 90 days in local jail, they don't even need. They're rolling straight out. So we're talking about folks who are being musical chairs across the state for the state's convenience. And then at the end of the day, they're going to send them back down here and say, okay, 90 days, sheriff, see what you can do with it. That's a joke. If the administration is really serious about this, the administration have access to numerous contracts. I've had this conversation with Colonel Sneed. When you're doling out these contracts, create a re-entry clause in that contract. To all these contractors that, you know what you want to do? You put your RFP out, and you say, you want this contract? Okay, we got a re-entry program. We got 2,000 folks coming back into the city that's going to need gainful employment, pulling the work. And I guarantee you, we won't need the jail anymore because crime is based upon economics. I don't care what the crime is, if it ended in a fatality, I guarantee you it started by nickels, dimes, and quarters. I guarantee you that. And so we really focus on what we're trying to do and kind of like read the letter of this. This is for folks who are sitting up in Pine Prairie somewhere, been there for 5 years, doing the state sentence. And now all of a sudden, I feel sorry for him with some empathy that I want him to go through a re-entry program. What is he going to learn in 90 days? Be honest. Everybody in the room, be honest. What is he going to learn in 90 days? Jack. You're going to learn nothing in 90 days. So come on, let's just be real about it. We really talking about helping people. We got to meet them a whole lot closer than this. 90 days ain't gonna get it. You know, so again, 200, we say 2,000 people coming this way every year. How are they coming this way? Are they coming in 6 this month, 10 next month, 20 the next month, 30 the following month? Come on, we don't have no